105.3, 95.3, WDXE.
That's us, and it's time for Stan Pierchoski. Stan, good morning.
Good morning, Jeff. How are you?
We've made it all the way to Friday again.
It is. It is time for bulletproof estate planning. We are here again.
And that is the kind that you offer.
That is.
The bulletproof estate planning.
I focus on the bulletproof part. You can do estate planning, but making it work is where the
That's right.
where the challenge and the work comes from. Because you know we talk about all things that happen.
Yeah.
And I'm going to talk about a few things like that today. This show is kind of, I don't want to say ad hoc, but I mean I kind of usually have a subject matter I want to talk about, but it's not really structured. And if if we get a call or something, it's about something to open up a different topic. I'm more than happy to go down that road. But
sure.
Before I get started, let's throw the phone number out there.
Absolutely.
If you want to call in, 766-9393. Pretty easy number to remember. Share an experience or ask a question. Go ahead. I'm more than happy to answer the questions and offer the time freely. But give us a call. But first of all, let me just start off. I like to keep people posted on my seminars, and I got another one coming up. It's July the 19th. So
yes.
It's about a month out, and it's going to be. We call it Will's Trust in the Nursing Home, and July 19th is a Saturday. We do that at 10 o'clock in the morning, and it's going to be at the Star Theater, which is right next to my office on the beautiful downtown square in Pulaski. The physical address of that, if you are coming, you don't know where it is 105 North 1st Street in Pulaski. So it's a great drive, and it's on the square. It's night, and it's a beautiful square. We'll have the farmers market going in the morning like that. So, but there's plenty of room to park. So if you want to RSVP for that, it's not too early. We've already got quite a list there, but we've got a big venue there. It's kind of like over here. We usually always get walk-ins, and we usually always get a good response to them. But we have plenty of room for that at the theater.
Absolutely.
So I'll bring that up again at the end of the hour. Like I often say, that if you hadn't been to one of my seminars, you might really consider it because we get great reviews on those things. And,
yeah.
I was going to talk a little bit about special needs trust today, but before I do that, I want to share an experience. We do a lot of TennCare planning.
Yes.
And TennCare planning is a unique area of the law. When I say unique, it's like I don't find many people that do it, and it's riddled with rules. I mean,
yes.
It is a quagmire of rules, and some inconsistencies exist, and agencies you deal with are inconsistent on top of that. So it's a very frustrating area. It's been around. The Medicaid system. We talk about TennCare, which is our version of Medicaid, right? The Medicaid Act, come July 30th, it will be 60 years old. July 30th of this year, because it came out in July 30th of 1965, and it's still not well understood by many attorneys or folks or organizations. I mean, people put stuff on the internet all the time. It's not right, or if it is ever, it's right, it's not complete, or it's kind of right but mostly wrong. I mean, it really is not the best place to get information on this topic. Yes. And that brings me to an experience. I get clients come in and they tell me all kinds of things, and they tell me about other people that they talk to, because I really don't know who around here does that kind of work. And I think it's because it is complicated. I mean, it's not so complicated you can't learn it, but I mean, it is for an attorney to do TennCare eligibility, you have to spend time and understand it, because the rules. It's not just a straight procedure. It's not like sitting down and writing a petition for, guardianship or something. And where you can go to the statute and says, here's what goes in the petition. You just do it. All the circumstances are so much different. All the different assets that people have, the different postures the assets are in, the different circumstances of the family. Oh, yeah. All these things come into play on the eligibility. And sometimes you'll have a theory or what we call a strategy, and you'll have to tack 2 or 3 of them together because of the different things that are going on. And it can get pretty cumbersome. And so that's why I often say it's not a good idea to do a do-it-yourself TennCare application, because I'd say 99 times out of 100, if not more, it'll be denied. Oh yeah. I mean, the only time they don't get denied is if the person that you're doing the application for is completely indigent. I mean, they own nothing. Then you're sort of qualified by default. I mean, that usually will go through pretty smooth. But if you're going to do that, you don't need me, because I deal with people who spend a lifetime gathering their wealth and want to hang on to it. Yeah. And get them eligible. And had a client come in and say they were looking for somebody to help them with estate planning. went to an attorney, and they said they weren't persuaded by their abilities, and I kind of asked why, just out of curiosity, and I was talking about the internet, and the response was, well, we asked him about 5 or 6 questions, and each and every one of them, he Googled the answer. No, I can't even imagine that. I get this picture in my mind of how you do that without looking like you're doing with that, and apparently you didn't. But it just strikes me, that would not go over big. I don't think,
Doesn't sound like
I
it.
like to think I know what I'm talking about. We're on this show. If you have a question, want to ask me,
Yes.
I don't have my books in front of me. I'll answer it from my knowledge, and I'm pretty sure I'll get it right. Maybe not. I can't say always. There could be a question out there that would. But and there are still questions out there that I'll have to go hit the books on.
Right.
I know it's like say, okay, I think I know where this is going, but there's a couple of things in my thought process that I need to fine tune to see if we can do it. So it is complicated, and and then I had somebody else come and tell me that they were dealing with the grandma who had gone into the nursing home, had been there. But they were told by an attorney to transfer their property, their real estate, the primary residence. When we talk about real estate, it comes in 2 categories: primary residence and other.
Yes,
real estate.
yeah, absolutely.
And the primary residence has is treated a little bit different. But they were told to transfer the primary residence to the 2 daughters. Well, now it was 2 years later, and they're in a nursing home, and that's causing a problem because we got that 5 years we have to deal with when you gift property away.
Right.
Anyway, it was pretty convoluted, and I was asking the person because they were there on a trust signing that we were doing. So it was, and the person there was their in-laws, okay? But they weren't there in my office. But the person that was explaining it to me said it was their in-laws, and I started asking a few questions about it. Then it turned out they had like 1 or 2 of their children had documented disabilities, which is a place where we can transfer assets without having to worry about getting that penalty period, and that was overlooked. And when you're an attorney, you're held to a higher standard.
Yeah.
Okay. Now, saying you don't know is never a good defense if you're an attorney. It's what my wife says. My wife says, stay in your lane.
Yeah.
I'll be in the kitchen. I'll start doing something. She'll say, stay in your lane.
Stay in your lane.
I'll take care of that.
Yeah,
You go
yeah.
do what you do, and I'll stay. And so when you're an attorney, when I stick with estate planning, I'm staying in my lane. If somebody wants to ask me a question about immigration or bankruptcy, I'm getting out of my lane, and I'm not going to give you an opinion because I'm going to say, look, I don't do that. I know some people that do. I have a general understanding of it, but that's it. I can't give you any kind of legal advice that you can rely on because I don't do it.
Yeah.
I know when I'm not in my lane.
It's not your area of practice.
A lot of people that just out there, attorneys that just don't recognize when they're out of their lane. And because, what's dangerous for us is when you get out of your lane and somebody, maybe you cause a damage and somebody wants to file a lawsuit, you're held to a standard of you either knew or you should have known.
Sure.
And that is, and if you say, listen, I didn't know that. I didn't know it. You're not going to get anywhere with that. You should. Well, it's like, well, you should have known it.
Yeah.
If that's what you do, then you should have known that.
Interesting.
So
that's a good thought.
Anyway, it might pay to shop around a little bit. Talk to people if you can find people doing that. See look at their reviews and stuff like that. Attorneys don't get many Google reviews. If you look around, there's some, but they're not many.
Right.
And some of them are years old and stuff like that. I've got pushing 50, which actually is a lot for an attorney.
Yeah.
And they're good. There's one on there that's not a 5-star review, and there's nothing written. It's just a name, and we have looked, and never was a client, so I have no clue where that one came from.
Don't know where that came from.
I don't know where it came from, but so if somebody writes something, I would respond to it.
Sure.
Or if they write a 5-star review, I respond with at least a thank you.
Yes.
But if there was something less than that, I would respond to the issue and say, well, what did we do wrong? What can we do better? But I got really good reviews. So just it pays to shop around, and if you're not comfortable, don't pull the trigger. Wait till you're comfortable to do it.
Yeah, that's
anyway,
good advice.
That was that. So the other thing I wanted to talk about is I've had some special needs trusts lately that we don't talk about much on this show, and I'm going to spend a little bit of time, maybe not the whole show, but what they are, what they do, because there's a lot of people out there that are in this boat.
Yes.
And you may not know this is available, and so I'm going to talk about it a little bit, because if you are, it is a very specific area of estate planning. And there's lots we can do, but this is very technical, because these special needs trusts we do are what I call a creature of statute. So when we make these trusts, there's not a whole lot of creativity with them, because they come out of federal law, out of the Title 42. And the federal law has created these things to give us the ability to do what they do.
Yeah.
Okay. So, when we talk about special needs trust, we're talking about people that get benefits. I'm not talking about 10 care benefits. Now, it could be 10 care, the under 65 10 care, but typically the benefits I'm talking about is SSI, Supplemental Security Income, or SSDI, Social Security Disability Insurance, okay? Those are the two we talk about. And SSI is specifics. SSI used to be called welfare. Now they call it SSI. And SSI is typically for people who may be born with disabilities that can't hold a job and take care of themselves, or somebody that has some sort of illness, some affliction that keeps them from being self-supporting. And so you qualify for SSI, and the qualifications for SSI are very, very similar to that of Medicaid, 10 care, the Medicaid system. The assets, they differ in the fact that what puts you eligible medically, but they're similar when they come to income qualifying and resource qualifying.
Right.
And so, the SSDI is a little different. SSDI is not necessarily a means-tested program, but when you get a government benefit, anybody that has government benefits, either of those two, it's a hassle to get them. I don't do that work. I stay out of my lane. I stay in my lane. I don't do SSI or SSDI qualifications or applying for it. There are attorneys that do that, and you can do it. It doesn't cost you anything.
Right.
The attorney gets paid from the Social Security. They get paid out of when they get that done. So it's not out of your money. But you hear people that say, I tried to get SSDI and they turned me down 3 times, and then they finally said, okay. And that's pretty typical, It's kind of like if you want to convert and be Jewish or something. They say no 3 times, but you want to make sure you really want to do it, right? Then they say yes. So you sort of have to have a little bit of tenacity to stick with it, and most people will get there if they got the disability. And so now once you get the disability benefits, you've gone through a lot to get them. So you really don't want to lose them once you get them. Now every month you got to recertify, which is like a little mini application that kind of says, hey, are you still eligible?
Sure.
Every 12 months. So once you get them, especially for people that are pretty badly disabled, we don't want to lose those benefits. Now, the amount of money that somebody that's on SSI can have is the same as 10 care. It's like less than $2,000 of these countable assets. Now, SSI pays a certain amount every month. It's a set amount for everybody that gets it. It's like $943 or something.
Right.
In that ballpark. It changes sometimes from year to year. They have a cost of living increase or some percentage, but it's a fixed amount. Now, SSDI is a disability, then your payment is pretty much based on the level of your disability.
Right. And
what everybody get for SSD is usually different than somebody else.
Okay.
And it can be more than that. It can be $2,000 a month. It just depends on the disability.
Right.
And so you have these benefits, and you don't want to lose them. So if you're in a position like, let's say a parent, and their child is a special needs child. It could be an adult child, and usually is, and they're getting these benefits, and they want to do estate planning. One of the things that will enter into their mind is, I really, I've got a certain amount of wealth. I've worked all my life. My wife has worked. We've saved up. We have some stuff, but I'm worried that if I've got 3 kids, and one of them's special needs. That's what I'm talking about when I say special needs.
Yes.
One of them's special needs, and they're receiving, SSI. And what I'm worried about is if I leave them all 1/3 of my wealth, it's going to over-resource that child. At my death, or at the second death, our trust says, okay, the kids all get 1/3.
Yeah.
And if they've got some money, don't need much. But if the child inherits, then they're immediately over-resourced.
Yes.
Okay, now, that causes a problem because when you are on these things, these documented disabilities, and money comes into you, you have until the first day of the next calendar month to do something with it.
Sure.
If you still have, so let's say you're below your $2,000, you got $1,500 in the bank, you're getting SSI, you've been getting it for a while and everything's going along smooth. All of a sudden Aunt Gertrude passes away, and in her will she left you $10,000.
Yeah.
And you don't even know it. Just shows up one day, get a call from an attorney, says we got a check here for you for $10,000 because Aunt Gertrude left you some money. Now, Aunt Gertrude put in her will, I leave this to my grandson, John Doe, by name. Now, that money is his. It's in his name. and the probate court or whoever, if it's a life insurance policy, the insurance company will not distribute it to anybody but that individual, which is a problem because the individual can't have that much money to maintain their eligibility for SSI. So if it comes in, let's say it comes in on the 15th of the month, he's got till the first day of the next month to do something with it. Now it's pretty limited on what you can spend it on, and so it's hard to do. If it comes in on the 29th, you're kind of screwed. And
Wow.
So if any of that money, if you have enough money of that left over that puts your bank account over $2,000 on the first day of the next calendar month that you received that, you are over resourced, and you will lose the benefits. They have no mercy. They do not have a sense of humor when your money runs over $10,000.
Oh, wow.
It's an absolute disqualifier, and they will. Now you're forced. Now let's just play this out. Suppose Aunt Gertrude leaves you $10,000. You don't get it spent, or don't do anything, or didn't know that you had to do something with it. That's probably the biggest problem. You didn't know you had something to do with it. You didn't know you had a time period to do something with it, and spend it on exempt assets for. You didn't know that. And so the first day of the next calendar month comes up, now you're over-resourced, and they terminate your benefits.
Wow.
Now what you have to do is you have to just use that money to take care of yourself.
Right.
Until it's gone, until you're down below 2,000.
Yeah.
And reapply. And you'll get it. You gotta go through the application process again, which is a hassle, but you'll reapply. And then when you get the benefits, now that's all you will have. It's just $950 some a month, right? That's all you have now because you had to use up Aunt Gertrude's inheritance money.
Yes.
So wouldn't it be better to be able to have access to a fair amount of money so you can have a better quality of life but still get the benefits? Okay. So enter a special needs trust. And a trust is a way for a person, for money to be there for their benefit, to enhance the quality of their life. But it's really not theirs. Okay?
Yeah.
So here's how it works. Aunt Gertrude dies, and instead of saying I leave $10,000 to John Doe, we would have her change her will or her trust, whatever instrument she had, to say I leave $10,000 to John Doe's special needs trust.
Yes.
That's not John Doe, it's his trust, and the trust is for his benefit. And this trust, he's not the trustee, nor does he ever get access to the money, but it's for his benefit. It's to be spent on enhancing his quality of life. So I like to think of a special needs trust like this. Theoretically, you don't need money. What you need is a roof over your head.
Yes.
You don't need money, you need food to eat every day.
Yes.
You don't need money, you need your house to be heated in the wintertime and cooled in the summer.
Right.
So you see where I'm going.
Right.
So the fact that the money doesn't go to the special needs individual is not that big of a detriment because if it did, it would get spent on things they need.
That's right.
So how about the trust spend it on things they need and it never goes to the individual and therefore it's never in the calculation for eligibility because it's not a countable asset. Why is it not countable? It's in a trust for my benefit.
Yes.
Remember, I always say the countable assets, if you want to understand them, for the word countable, insert the word available for the cost of care. So if it's in the trust and the trust buys a house for that child, or buys food, or whatever, pays rent if you don't buy the house,
right.
or anything. The child never had it. So if they say, well, we're going to disqualify you because you're special needs trust, we'll say, well, that's not in the equation because it's not available to me. I can't get at it. I could not go write you a check on that. I'm not the trustee.
Right.
I'm forbidden to be the trustee. It's for my benefit. And so it can buy me clothes. So you can have $1 million in one of these special needs trusts and still be eligible for TennCare or maintain your eligibility that you're already getting. And that's exactly what they're for, and that's exactly what they do. Now, there are creatures of statute, meaning, there's a few things we have to put in there, like who's going to be the trustee. And when we have that, it's probably not always a good idea for the parent to be the trustee because, or at least a successor trustee after death, because there's a lot of rules that deal with special needs trusts, not like our other trusts. Other trusts we do that I talk about all the time, the revocable living trust, the asset protection trust.
Right.
The rules on those, you write the rules on those. I mean, the rules that you have to obey for those to be valid trusts are very simplistic. This is very different. There's a lot of rules associated with these. And so we actually have in Tennessee several professional special needs trustees organizations. There's one called Cumberland Trust. There's several of them out there. But sometimes that might be a better choice. It's a paid position, but they follow the law. You know what I mean? Because if you don't know what you're doing, because for some people that insist on doing that, I have a brochure that I put together. It's called Administering a Special Needs Trust, and it's
Right.
it's pretty involved because there's a lot of stuff you have to do.
Right.
Or know. So you don't just take that fiduciary relationship on loosey-goosey, because you can screw things up. And like I said, they are very unforgiving when you make a mistake. And the last, what they don't give you any slack on is if you can say, I didn't know. I'm just a guy, I didn't know I had to do that. They say, well, you chose to be the trustee, therefore you knew or should have known. And that's a standard that will hold up.
Right.
So we want to be careful. And so, but they're grand tools for that, okay? Because, a thought that might wake people up in the middle of the night is, if I have a special needs child, what's going to happen to them if something happens to me?
Yeah.
And that's a valid thought, a very valid concern. But this is something we can do. Now, it can't replace you if something happens to you, but it can certainly stand in your financial shoes.
Yes.
And be supportive of this person with a trust. And most trusts people have, they don't even fund them until death. They have a trust, they put $100 in it with a bank account just to keep it alive. Because the child is living with you and you're the parent, you pretty much are taking care of the child by place to live, food, all the necessities of life. So there's no need to put money in the trust and get this for them out of the trust. You just
Right.
get it for them. Same thing, it's your money, buying it for them. But then at death, most people leave their inheritance or a portion of it to that trust
Yeah.
to continue doing what they were doing when they were alive. And so and also not jeopardize the benefits. Can't tell you how many people have come into my office that happened to them and then they pulled the benefits from them. And it just didn't have to happen. It just didn't have to happen. So, if you have a special needs child, or even if it's an adult child, typically, most times it is, and they're getting either SSI or SSDI, and you're worried that they might, somewhere in the future, inherit something or run into some money,
Yeah.
that it will disqualify them, that's a valid concern of yours.
Yeah,
Good
absolutely.
thinking. You're thinking right. Something needs to be done about that to protect that, because if that child loses that and they don't have the ability to take care of themselves, it's a real problem. They can they just become a ward of the state, and then the quality of their life is really taking a nosedive.
Yeah.
And so we don't want that to happen, and that's what the special needs trusts are designed to do.
Yeah. What strikes me, Stan, about this sometimes is how easily surprised we could be by our circumstance in this.
Yeah.
Because we haven't, taken the time to consult with someone and do some pre-planning, that kind of thing. And I see it a lot. I see it a lot in families and estates and things that happen, we're like, okay, we're just handed a circumstance that we weren't expecting because we hadn't planned for it, that kind of thing.
Oh, yeah. In real estate, it comes up a lot.
It comes up a lot.
Because most people have real estate and they leave it to their kids.
Yeah.
And
Yeah.
now we're dealing at death.
And they don't know. They don't know that that's what's going to happen, and that's
right.
That's a real problem. And look, I've learned over the years too, myself, about this stuff, and I'm like, okay, have you thought about this? Have you thought about that? Because they don't deal with it every day. Oh
no,
they don't deal with it every day.
And there's stuff, like I say, here we get back to this thing about, you may go to a professional for some advice, and if they don't deal with it every day, the advice can be questioned.
They don't even know what to ask.
I mean, it reminded me of something in
Yeah.
real estate. I want to finish just a little bit on special needs trust, but I'll come back to it.
Yeah.
Had somebody come in and they were talking again about it, their an in-law or grandma or something, and they were saying something that didn't make sense to me. I said, well, typically it works. I'm curious as to how that got that way.
Yeah.
It had to do with a house that they transferred, and they said, oh, they transferred this thing like 8 years ago,
Yeah.
and they still ended up taking $40,000 of the value of that house or something like that. I said, well, none of that's making sense until we got talking about it. And then the person said, how'd they come after the house in estate recovery if she didn't even own it? She didn't own it 8 years ago, right?
Right,
She
right.
deeded it away. And then the person said, well, she had a lifetime dowry. Now, that's not the word we use. I hear that a lot.
Yeah.
What they're referring to when they say that is what happens when she transferred property, she retained a life estate.
Life estate.
Now,
And they assign a value to that.
and that is a value for that. You're right. And,
Right.
they didn't know that. And they found that out. And here's what they do. If a life estate is an old common law form of action. We still do.
Yeah.
It's been around forever. Like I
Right.
said, it's firmly rooted in our common law jurisprudence. But what people would do is they say, I'm going to give the house to my kids now. Now, you can do it for whatever reason.
Yeah.
A lot of times these days they do it because they think it'll escape ThinCare.
Right.
But it could be other reasons. But the theory is, okay, if I give it to them, I'm deeding ownership to the kids. Now, what if the kids, if they could turn around the very next day and give me the boot?
Yeah.
I mean, maybe not the kid, but maybe the in-law might.
Yeah.
Who knows? But they could, because, why? Because they're the owner. So they could turn around and say, get out. And you're like, but I gave you this house. Yeah, thanks. Now get out of my house.
Yeah.
I mean, that could happen.
Yeah.
And so, for whatever reasons, I'm embellishing, but
Sure.
but to make that more secure for the giver, you know, say, okay, I'm giving you the house, but I'm going to retain a life estate.
Right.
So here's the way to look at it. When you have a home or real estate, you have what we call a bundle of rights, but there's a lot of them. You know, there's a right to lease, the rights to anyway. But I'm only talking about two rights. One is called the future interest, and one is called the present possessory interest.
Right.
Those are just two of them. The future interest, sometimes you'll hear people call it, is the remainderment, or the remainder interest.
Yes.
And the present interest is what we call the life estate. So what you do is, let's take a $100,000 house. And I use that number because it's a nice, easy number to do in your head. You won't find a $100,000 house, as you know.
Not much, no.
But it's a nice, easy number to do in your head. So you say, you know what, I'm going to give this to my kid. I'm not even going to go for the reason. We just decide to deed it to the kid. But you know what, I don't want him to kick me and the wife out, because, you know, the kid never would, but his wife doesn't think too much of us, and she probably would make him do it.
Right.
So we want to live there for the rest of our lives. Okay, here's a deed, we're going to deed it to you. We actually construct a deed that here's to son,
Right.
John Doe Jr. And you say, here's a deed from John Doe to John Doe Jr. We're giving you the house. $10, love and affection, or, you know, some token consideration. You know, you're not buying it, we're just giving it away. Now, but in there it says, but we're expressly reserving a life estate for my wife and I.
Yes.
So we didn't really give them the whole house. We gave them the future interest. No, because we retained the present possessory interest. We're going to live there while we're alive. And he's going to own the future interest. And the theory is that at our death, or for the couple, it's the second death, at that death, that life estate will expire worthless. And all the rights will now reside with the remainderment. He'll have the future interest, and he'll also have the present interest when the life estate dies.
Right.
Okay? So, but what happens when you actually do that, when you sever that? Well, okay, they put a value on that, what you're retaining. Well, how do you put a value on a life estate? Well, I'll tell you how they do it. You won't like it, but here's what they do. You go to Title 26 and the tables in the back, which is the Social Security, which is, Social Security, and there's a life estate table. And you go to that thing and you go down to there's three columns. The first column is age,
Yes.
and you go down to your age at the time the property was transferred, okay? Now, they'll put the value they put on the property, they'll go back in the tax records and they will use the tax assessed value at the time you transferred it for that year, okay? So you go down, let's say, 70 years old, you go down to 70, and you go across, there's only two columns in the table. One is called the remainder interest, one's called the life estate interest.
Yes.
Each one has a decimal in it. It's surprisingly, you add the two together in any row and they add up to one, okay?
Yes.
So the remainder is what you gave away. The life estate interest is what you retained.
Right.
And it somehow magically, at a lot of ages, hovers around the 60-40 area. It's somewhere in the 30s, somewhere in the,
Okay.
but it depends on age. But so we'll use that as, because I see that number come up a lot. So what you gave away, $100,000 house, you gifted away $60,000 for the house, to the remainder.
Yes.
But you retained $40,000. That's an asset that you have.
Okay.
And that's something, when they said that, I said, no, and they said that they were coming after the house. I said, now I see exactly what happened. They retained the life estate, which is an asset, passed away. I mean, before they passed away, they said that's a countable asset. A life estate is a countable asset. So it's a problematic asset too, because what do you do with a life estate? You can't give it away. If you give it away, you got this gift problem, right?
Yes,
You
exactly.
could give it away.
Yeah.
I'm just saying,
Yeah.
and you can't really sell it.
Yeah.
Who's going to buy a life estate? Now, if you come to me and say, "Hey, would you want to buy my life estate?" I'll say, "How much you want for it?" Or I'm going to say, first of all, how much you want for it? I need to know, well, when are you going to die? When is it going to be mine? And it's, well, I don't know when I'm going to die. Well, then I don't know what to pay for it. I might pay more if you were dying tomorrow, but I'd pay a whole lot less if you were dying 10 years from now. So it's an unmarketable title. You can't go to the free market and sell it.
Yeah.
The only person you could sell it to is the remainder of it, the person that owns the future interest, the one that's going to get it anyway.
Yeah.
But then if you sell it to them, then now you can't undersell it.
No.
Because you get dinged with
So you're getting
partial gift.
You're getting a benefit.
But if you sell it, now you have the $40,000 asset.
Yeah.
So it's okay to do a life estate. You just don't do it for these avoiding 10-care purposes.
Yeah.
That's not a good tool. Now, there's a way to deal with it. I have a philosophy, I have a theory, not a theory, but I have a strategy we use that deals with life estate that works like a champ.
Okay.
But it works within the rules, you know.
Yeah.
And it's pretty number heavy and complicated. But I brought up the life estate because you got into the real estate thing.
Yes, exactly.
And that's the kind of stuff you'll run into.
All the time.
And now it's like, oh, who does own this piece of property? I mean, it's owned by two people. And you know, when you have a life estate, as long as I'm on the topic, if the remainderment, in this case the son,
Yeah.
suppose the son got approached, suppose it was a piece of property, it was 100 acres, and he got approached by Dow Chemical and Pharmaceutical Company or
Sure,
something like that.
sure.
They said, we want to buy that. We want to build a factory here.
Yeah.
That's perfect 100 acres. It's a perfect place for our factory. It's got the ingress. We got, we're out of the zone, so we can pollute as much as we want.
Yeah.
And all, whatever's perfect to them, they want to buy it. They make him a deal he can't refuse. So this is worth $100,000. We'll give you $1 million for it.
Yeah.
That's how much we want it. Son says sold. Okay, what happens to the life estate? Well, the life estate runs with the land, which means when Dow Chemical buys that property, they are now the remainder men, but that's all they are. The life estate must be honored.
Yes.
So that affects the price when people buy the remainder interest and stuff. But so if you have a life estate, one good thing that is about a life estate, if the property gets sold by the actual owner, which is a remainderman, the life estate is always in effect.
Can it be dissolved?
Yes, you can, but you have to. I mean, if it's your life estate, sometimes the language will say for the rest of your life.
Yes.
But sometimes I put in my trust and stuff. If somebody wants to do that, I do a little more, and I'll say something like, let's say it terminates upon death, or it can terminate upon you not occupying it anymore. Because, you know, if you have a life estate and the person decides, you know what, I'm moving to Florida.
Yeah.
They're down there and they get this life estate, nobody's even using it or occupying. You're not. It's a present possessory interest. You're not possessing it.
Right.
So I say if you're not occupying or living there, that terminates the life estate as well.
Okay.
Sometimes we say you have a life estate, but if you ever get remarried, sometimes that comes out of a divorce and stuff. If you
Interesting.
get remarried and somebody that can support you now, it goes away. You can put terms and conditions on it. Now, if you didn't, it's just said at death, and you want to. I say, I'm moving to Florida. How can I give everything back to my kid? You can do just about anything by agreement.
Yeah.
You agree to terminate the life estate because it's for your benefit.
Yeah.
What you can't do is terminate it without the life estate holder's consent, right? Because it's theirs. But you know, in that case, Dow Chemical would come in and offer them a boatload of money to go somewhere else.
Right. To terminate.
So yeah, you can do that.
Interesting.
You can do it, but it's not such. It's a problematic asset when you deal with long-term care.
Well, I didn't think of that moment just this week.
Cool.
I didn't think of that. We had an estate where there were sibling heirs, a group of sisters.
Brothers. Okay. Yeah. No.
And the agreement was, you know, and of course the inheritance is divided equally among the sisters, but. Prior to us closing, one of the sisters was very ill and passed away. Okay, and so during the process of closing, they have to get a 10-care release for her because she was cared for in a nursing home. So,
Does she have children?
And she has children.
Okay, well,
so
they step in her place.
Yeah, so there we go. So anyway, let's see if we can get a phone call in here.
All right.
Somebody may want to talk to us. Hey, good morning. You're on WDXE with us.
Hi.
Oh, they didn't want to talk to us.
Sorry.
Okay. Evidently, they wanted something else.
Well, you know, if when people die and you're supposed to file for a 10-care release.
Yes.
Now, if you go through probate, which is a court-monitored process, right?
Yes.
It's a requirement of part of the probate code is every estate. Now, people say, you know, we never had 10-care. We never did anything. We never did.
Right.
You still have to file the document.
Still have to file.
Send it in, and if that's the case, it comes back and says, no, 10-care says, we never had a claim on this. We do not have a claim on this estate.
Right.
What you're asking 10-care to do is give a release.
Yeah.
Now, if you did have a claim on it, here's what you get. If you were in the nursing home, and for any length of time, you send it in, you're going to get like a 16, 30-page document itemizing everything they ever did for you. And they're going to say, we have a claim on the estate to the tune of the sum total of all these pages of what we've done for you.
Yes.
$250,000. And we want paid back. You didn't know TennCare, when they approve you and pay for your long-term care, you didn't know that was typically kind of like a loan, did you?
Yeah.
That they're gonna wanna get paid back.
Yeah.
They don't tell you that. Well, I'm here to tell you, there's people out there that listen to me that have gotten that surprise letter in the mail. So-and-so was in a nursing home for 3 years, they passed away, and you get a letter from TennCare that says, you owe us, or her estate owes us $300,000.
Yeah.
It's like, but I thought she was approved. She was approved. We want paid back.
Yeah.
How's that for?
It's a whole different world, isn't it?
Yeah.
Yeah.
But
Yeah.
but yeah, so you have to file that release. They will never, they will not close a probate estate without it.
Yeah.
But then if that person passed away, now the property's owned by the two sisters and her children.
Yeah, and I'm assuming that if of course, if there is no TennCare lien or claim on the property, then all is well. They release and we're done. But if there isn't a claim, if there is a claim on her estate, and she inherits part of this property, can they demand a part of that, or is it
Oh yeah,
pass right?
they can take her third.
They could take her third or fourth or
Now,
whatever.
if
it
it's
is.
her, the benefit, she's one of the sisters, right?
Yes.
If it's her, yeah. Now, if it had been one of the parents, they can get all of it. But she inherits a third of it, right? So she owns a third. The other two own a third.
Yeah.
They can have a claim. They can have a claim on her third. If she had gone.
That's right.
If she had.
That's
had
right.
any TennCare
Yeah,
benefits.
if she has TennCare benefits, yeah.
I mean, we're talking about a third of that house.
Right.
Now, but there's a solution to that,
There is.
where they can't do anything about it. And what we're talking about is estate recovery, which is how they go after property at
Right.
death. Now,
Right.
they're gonna go after what's ever in her state at her death. And because, I don't know, it would depend on whether she had a will. Let's say she didn't have a will.
Okay.
So if she didn't have a will, then whatever she owns goes to what we call persterpes. It flows through her, it goes to her descendants.
Yes.
So if she got 3 children, they inherit her third of everything.
Right.
The house, the money. Now, when they have a claim, they can go after the money. But let's just say the house is the only thing there.
Yeah.
And she inherits a third. Now, what does that do to the other two sisters if TennCare has a claim on the deceased sister's third? Sounds problematic, doesn't it?
It does.
Well, they can, here's the way it works, and here's how you fix it. And listen, I probably ought to have some kind of disclaimer that I say, because when I'm superficially talking about this, so don't run out and do what I say, because it's as simply as I say it, because there's more to it.
This is a theory.
Well, no, it's not a theory. It's a strategy.
It's
that
a
works
strategy.
works very well, but it has to be done a proper way.
Yes.
And it is one that gets a lot of scrutiny, so it really has to be done right.
Yeah.
Otherwise, it won't work. But the way it works, the strategy is technically the property's co-owned. Okay,
Yes.
by 3 people. Well, now by 2 people and the heirs of the third. But let's just say it's co-owned by 2 people and the estate of 1 person.
Yes.
TennCare Estate Recovery will go after property. Now, the only way they can recover is to sell the property. Because they don't want property, they want the money. Right? They want what's owed. The only way they can do it is they can sell the property. Now, TennCare in the state of Tennessee long recognized the law that you cannot force a co-owner to sell their property. So if they can sell their property, they're going to recover. But what we do is we have the other 2, or at least one of them, just sign an affidavit that says, I refuse to sell. Now, when that happens, the asset becomes, by law, an inaccessible asset. They mark it as inaccessible and move on. They can't get it.
Interesting.
Now, that's what happened in that case, okay? Let's get creative. Let's say, let's get creative. I mean, that's how it works. I mean,
Okay.
that's not what we call first Pierchoski 14, you know,
Yeah.
it's not some gospel that I made up. That's the way estate recovery works. And the words I used actually come from court cases where the courts say, you know, Tennessee long recognizes the common law concept that you cannot force an owner to sell their property.
Yes.
Let's back up a little bit and say, okay, I have this house, and Aunt Gertrude owns this house, and she's in the nursing home. She's already there. Let's make it dire circumstances. She's already there.
Yeah.
And she is not doing well.
Yeah.
She's not expected to live very long. She has this house, or she owns this farm, or something. And if she passed away, she'd been there for years. They probably got $300,000-$400,000 claim on her by now.
Yeah. Yeah.
We have to file our TennCare release. They're going to buy a claim. They're going to want paid. They will use this property of hers to pay it. Because
Yeah.
if she passes away with an ownership indicia, it's subject to the Estate Recovery Act. So let's say we have a bunch of people involved. I don't know, it doesn't have to be children, it can be anybody, but let's just say she has 3 or 4 children. And we say to them, can anybody afford to buy 10% of this property? Buy it, not give it away. You can't give it away because we're at the 11th hour now, we don't want to have to deal with a 5-year giveaway, right?
Yeah.
Does anybody buy a 10% interest? Or I like to go for 20.
Yeah.
I don't like to push the envelope, but anybody buy 20% of this? And if one can do it, or others can do it collectively, buy it. Let's do a deed right now and buy it, money change hands. Right now, when they come after the estate, the property, we're in the same boat as your example, and they say, okay, we're coming after her 80%, and the 20% says, we refuse to sell. So you cannot recover because you cannot sell. So now we've used the exact thing, but we backed up, got creative, and structured it that way to fit our purposes.
Interesting.
Or sometimes if you're way ahead of time, and you want to do it way ahead of time, you can give away the 20%. Now, that you can, when you give away the 20%, that you can do that, but you got this 5 years to worry about. So
Right.
if you back up in time when nobody's in a nursing home and you're not really worried about it just yet, give the 20% to your kid now. After 5 years, you've got a co-ownership. Then you don't have to worry about the 5-year penalty rule anymore, and so now you're in the same boat.
So, does that run in perpetuity? I mean, if they some way down the road decide to sell?
No, once they are by law under the 10 Care Act have to declare it an inaccessible asset, and once that's done, it's finished.
Okay. Okay, that's puzzling.
Well, we where this comes up a lot. I mean, when you do it with land, it's very technical.
Yeah, I would say.
I've done it, but for it to fly, they're going to look at it. I mean, they
Yeah.
don't like it, but they know how it works. But here's a place where we do this a lot. When people have an LLC,
Yeah.
and somebody says, I got this LLC, and it's got value, it's income producing, whatever it is. Let's say it's a rental car thing or something, or a car lot, whatever.
Right.
And it's an LLC, and my son owns 50% and I own 50%. We have this LLC. So I said, well, you have this, because it's an LLC, it's an asset like anything else.
Right.
When you look at LLC, it's like, what's it worth? Well, I don't know, but it's worth something.
Yeah.
So it's like money in the bank, or it's like having a house or a car. It's an asset. It has money. It has value.
Yeah.
And so we want to protect that. So it's like, okay, let's do the same thing. But here's what we do. Every LLC has an operating agreement, right, which talks about how you conduct business,
Yes.
how you govern yourself. In the LLC, in the operating agreement, we want to put some language that says, no shareholder can transfer or sell their shares without the approval of all the other shareholders. Now, what have we just done with father and son with 50% interest? It's co-ownership, and now we put in the operating agreement that they can't sell it. So when dad dies and they come after dad's 50% of the LLC, the other 50% owner says, wait a minute, you can only recover if you can sell his shares. And before you sell his shares, our operating agreement, which governs and has precedent, says you have to have our permission first, and we don't give it.
Yeah.
Tinker says, well, I guess we're screwed. We've got to make this an inaccessible asset and move on to something else.
So they never come back on it
They
ever?
can't. No, it's done. I mean, we do that a lot with LLC.
Interesting.
Like co-ownership. Now, again, this is the disclaimer. Co-ownership is complicated. Now, because here's why. Let me just tell you what somebody will think of.
Okay.
I talked about saying, okay, 50% of the LLC.
Right.
Suppose you got an LLC and you're 100% owner.
Yeah.
And we say, you know what, why don't you give when you're not going to nursing home for 5 years, or why don't you sell some of your LLC to your child because it looks like you're heading to the nursing home pretty soon, whatever. And I usually go for 20%. Why? I've seen it work.
Yeah.
I've seen it, no questions asked. Would that work for 10%? I don't know. I think it probably would, but 20. I know 20% works. Now, so I always get some genius who says, "What about 1%? What about 0.1? What if I bought 0.000000001%, which was like $5?
Yeah.
Would that work?" You know what? Theoretically, I say yes, but as a matter of practical fact, I think that would be a tough road to hoe. Because
Yeah.
when you're dealing with what I call form over substance,
Yes.
you have a problem.
Yeah.
20% is a legitimate sale.
Yeah.
10% might be, but I just don't like to beg the lightning to strike. If the people buy and said, that, hey, this is the money, this is all the lead we got in our pants, and we can only buy 10%. I mean, well, if that's the only game in town, we'll just have to do it and see how it works.
Yeah.
I think it would be okay, but but I'm not gonna go to 0.0001%.
Yeah.
That's a problem. Now, I've never seen how that was dealt with, but you can see right away, throw it out there. That's why I say disclaimer, because somebody's going to run out and do that with some ridiculously low fraction,
Yeah.
and it won't work.
Yeah.
For whatever reason.
Yeah, that's interesting.
Because, you know, there's a good faith element in all laws. You know, everything is in good faith.
Yeah,
That's, even though it's not written in the statutory scheme, the law in general is, you know, you operate in good faith.
so,
And so, but selling one millionth of
Yeah.
of a fraction is not in good faith. You're doing it to avoid this creditor.
yeah,
And that's working a tort against that creditor, and it's not genuine, what you're doing, it's not in good faith.
yeah,
Now, 10-20% is a good faith arm's length transaction.
yeah, I can see that.
And so, let's set it up and do it the right way. You know, if you wanna mess around and do that kind of stuff, then I'm sure you can find one of those attorneys that don't stay in their lane, that'll do it for you. If you ask me, I'm just gonna say, I'm not gonna do that.
Yeah,
It's just, you know, it's like asking me to do something I'm pretty sure won't work, and why would I do that for you?
yeah,
So, but I mean, the strategy is sound. And it's not my strategy, it's in the 10 character.
yeah,
What they can do and what they can't do. That's how you make it work for you.
yeah.
One of my favorites, I talked about it before, but I don't have time to talk about it now, I call the Tennessee two-step. I've
Yeah,
talked
I
about
think
that before.
we've talked about that, yeah,
You know, that's when you can give stuff away to people where you don't get a penalty period.
yeah, exactly,
you know,
exactly.
but,
It seems a little puzzling to me, though, that you could do that in this particular case and say, okay, we refuse to sell, we're not selling. And then 10-Care says, well, we dust our hands, we're done with you. And then could they turn around, you know, a month later and sell it?
Are we talking about the deceased?
No, well, the folks that are not deceased, the ones that said, no, we're not gonna sell.
Well, who are they gonna sell it? If they can turn around and sell it, sure.
Okay,
But now you have another co-owner. Now, here's the problem. If the co-owner says, yeah, I'll sell, then
Yeah.
10-Care can recover.
yeah,
They can recover from the percentage the deceased owns,
okay,
but they can do it.
okay,
I mean, so a co-owner can always agree to sell, but you sell it to a family member that wants to keep the asset,
okay,
and they're not likely to sell, but I mean, they could turn around and sell.
okay,
Now, I think what maybe we're trying to get at is, suppose you have this, they chalk it up as an inaccessible asset, and 10 years later, the deceased wouldn't have an interest anymore, his would go somewhere, like
Yeah.
to his heirs. So in other words, let's say the 50-50 split.
yeah,
It's estate recovery, we're talking about 10-Care estate recovery, which happens at death.
right,
So his estate owns his 50%, and the son owns 50%.
yeah,
Now, somewhere in his estate, he's either got a will, a trust, or the laws of intestate succession. They're going to transfer his 50% somewhere. It'll go where the trust says to go, which would probably be to the kid that owns the other 50%,
yeah,
or something. Let's just say that's where it would go. Or it could go to another child. Let's just say you say in your trust, hey, if I pass away, my 50% goes to my son, who has the other 50% because he's working the business. And,
right,
or you have a will that says it goes there. Or if you don't have it either, the laws of intestate cessation say it's going to go to my kids.
right,
But it's going to go to somebody. Okay, now, the estate recovery happens as the person is deceased and they're dealing with their estate.
right,
Because they own that and it's part of their estate. Now, they chalk it up as an inaccessible asset. The ownership of that now transfers to whoever it's supposed to go to, either by trust, will, or intestate succession. And now the other people own it. It's no longer an asset in the probate estate that they're going after assets in the probate estate.
yeah,
And so when the probate is finished, so 5 years later, they can't come back because it's never going to be owned by the deceased again.
yeah,
Because the
Okay.
estate is just an extension of his life, legal extension of his life.
yeah,
And once that's closed, they're never going to own it again. The claim is on them or their probate estate at death. Estate recovery is a interesting animal.
It is.
When you try to understand
It is.
10-Care, about 40% of it's estate recovery.
Yeah.
Maybe even, I mean, the other 60s mostly eligibility, but
Yeah.
there's a lot to estate recovery. Now, to make things more complicated, here in Tennessee, we are, you can have a standard recovery estate, which is only in the probate estate, which we're not, which we were, which means if you had a revocable living trust, everything's protected. Or you can have an enhanced recovery state, which means just about everything's fair game. 10-Care is what we call a hybrid. We're somewhere between the two because of some court action that took place. There was a case called the Smith case that they came up and said, if you pass away with any indicia of ownership of real estate, that's subject to the estate recovery, and that includes right of survivorship, which is supposed to actually transfer the moment of death. So do you have an interest in property if it's a right of survivorship that transfers right of death? According to the courts, yes. And that's something they can go after. Okay, so if that's something to go after, then we start working on what strategies can we deal with to not have ownership in property at our death. And that's, I mean, if they say if you have any ownership in property at your death is subject to estate recovery, so isn't the inverse of that true? Okay, if I don't own any property when I die, then there's nothing, they can't go after it.
Right.
So that's the overall goal, and there's many ways to accomplish that.
Interesting stuff. Very interesting
Because
stuff.
what we were talking about is, yeah, I have it, but they can't sell it, they can't
Right.
recover.
Yeah.
So, and again, when this happens, they don't, you know, they know how it works.
Pretty amazing.
They just look to see if it was done wrong, because it usually is, you know. So anyway, I'm sorry, you were saying something?
Well, it's just, it's getting the surprise, you know, and what happened to me was, oh, I didn't think of that. And it's like, oh my gosh, they do have to do all that. They got to get this in this particular case.
It's a lot delay.
So it's
Listen,
all
we are counting down here, so. let me
We
go
are,
real
aren't
quick. We got sidetracked there. Remind me next week, I'll talk about, the special needs trusts come in two forms, a first party and a third party, and they're different, and I'll talk about them. But let me remind you, we got the seminar coming up on July the 19th at the Star Theater in Pulaski, Will's Trust and Nursing Home.
Yep.
If you want to sign up for that, or ask me a question about anything, call my office at Pierchoski Estate Law, Pierchoski Elder Law, at 931-363-7222, or you can go to my website, which is estateplanstand.com. And you can ask a question by email or get the phone number. And for the gentleman that came and hired me last week who said, when I'm on this radio show, I only say my phone number once and I say it too fast. You can call me at my office at 931-363-7222. I wish I had a catchier phone number, but I don't. So.
That's a good phone number, really. It's easy to remember.
I mean, it was like 1-800.
Yeah.
Estate, something like that, but 363-7222 or estateplanstand.com. If you can't spell that, well, that's as easy as I can make it.
It's not hard to find, really.
And you can get my phone number that way. So yeah, we're here every Friday from 8 to 9 with Bulletproof Estate Planning, interactive show. You can call in and ask questions. So it's always a pleasure to be here.
Always good to have you, Stan. Stan Pierchoski, everybody. Pierchoski Estate Planning, and of course located on the square there in Pulaski, Tennessee, next to the Star Theater, and always something good going on there.
Yep.
And you've got that seminar coming up on
July 19th.
The 19th, just about a month away. And again, that phone number 363-7222. Thank you, Stan.
See you next week. Right on. Right on the money.